I now call the second case on this morning's docket, case number 119270, in the matter of the petition for a writ of habeas corpus by Richter Bowman.
Mr. Chief Justice and members of the Supreme Court, Petitioner Richter Bowman appears by Mark Dinkle, Salina Public Defender Office.
Mr. Dinkle, let's give a moment for the crowd to leave the courtroom. I don't want them to disrupt your arguments or opposing counsel.
Appreciate
it. You may proceed. Thank you.
Would ask for 3 minutes in rebuttal.
3 minutes is granted.
This case arose out of a jury trial in Saline County in March of this year, where Mr. Bowman was charged with rape and aggravated criminal sodomy, other offenses surrounding his 3-year-old granddaughter, and that occurred in the background of some custody litigation going on between the parents. During the trial, the state presented several witnesses, starting out with a 911 call to the police, reporting the concern of the molestation by the mother of the child. Defense objected to that call as containing inadmissible hearsay and possibly offending confrontation rights of Mr. Bowman. Then the state also presented more hearsay evidence concerning the molestation through the maternal grandmother, what her daughter reported to her, and through an officer that was sent to the child's residence to investigate the claims. The state presented that evidence over defendant's objections on hearsay and confrontation, which the court overruled and allowed the state to proceed on that basis. Then the state elected to eventually call AJMB in the matter and present her testimony. She was called to the witness stand. She was asked numerous times to accept an oath. There was even one erroneous attempt to administer an oath in which the court reporter asked AJMB to answer Ms. Ladner's questions truthfully. AJMB didn't respond to any of those attempts that occurred over 2 separate sessions. The first session resulted in no response. The second session also resulted in no response, with AJMB fleeing the witness stand at the end of that session. There were some indications early on that there could be problems with AJMB testifying at a competency hearing. She also refused to provide her first name, eventually spelling it out. But when she refused to accept the oath at the trial, then the state advised it was unable to proceed after 2 attempts, and the defense objected to declaration of any mistrial at that time. And that objection then raises a manifest necessity standard to be applied with strictest scrutiny when there's a defense objection to mistrial.
Is that all it takes? Is it an objection to raise it to the
That's
strictest
under Arizona versus Washington, is the objection to the mistrial. That raises the strictest scrutiny standard. That means we're not consenting to mistrial. We're not trying to run away from a trial. We are here for trial, and we're ready to proceed. Despite that objection, the court granted a mistrial, finding that basing its decisions on incompetency of the witness and prejudicial conduct, under although he didn't specify under subsection C of the mistrial statute, he cited that the inadmissible hearsay that came in over our objection. And so this is I guess the first time I've heard of other parties causing a mistrial and then the defendant suffering for it. With the declaration, it wasn't the defendant's conduct that prompted the mistrial. I asked this court to issue a writ of habeas corpus dismissing these charges with prejudice. We have to look at the declaration of the mistrial over the defendant's objection through the magnifying lens of strictest scrutiny that Arizona versus Washington demands. And what do we find when we apply that magnifying lens of strictest scrutiny to this declaration of mistrial? We find an alleged victim refusing to take an oath for unknown reasons, or as the state says in their briefing, for whatever reason, is what the term they use, for whatever reason, which could be anything, that she refused to take an oath. That sort of rationale doesn't seem to me to survive strictest scrutiny or create manifest necessity. The court itself said it did not know why the witness refused to take the oath. Pardon me?
Was there testimony, or not testimony, but statements made by the child victim in this case prior to the trial? I mean, there was a CAC interview. There was that interview, and there was statements to the police also, or just the same interview?
I believe that there were statements that the child made to the mother at Walmart. And then those were brought forward in a CAC, Child Advocacy Center interview.
Right. Okay. And those are those the only statements that were made? There's some reference to a competency hearing involving the victim? Yes,
and she testified at the competency hearing about differences in perception, like perhaps implicating her ability to tell the truth versus a lie.
So there was that, but then did that then follow with describing the events that occurred that she alleges?
That was not done.
That was not done. So the only interview that statement that would be made was from that sexual assault.
As I recall, it was the statements to the mother and statements in the Child Advocacy Center interview.
Thank you.
So we have in this background an unidentified reason for the alleged victim not to take an oath. That no reason has been subscribed to that. We had a motion to dismiss filed following the declaration of a mistrial. There was a hearing on April 6th on motion to dismiss. No explanation was provided in evidence as to why what happened. Then we have the court itself struggling with the reasons for mistrial, first indicating that it was declaring the mistrial due to witness incompetency and admission of inadmissible hearsay evidence over our objection, and then relying on physical impossibility under the statute, physical impossibility to proceed with trial in conformity with law, and then also the court indicated at page 48 of that transcript on April 6th, it had no information of prejudicial conduct outside the courtroom, and the only prejudicial conduct that can be cited in this case is that occurring inside the courtroom where evidence is admitted over the defendant's objections impacting on his confrontation rights. There was a failure to explore alternatives to mistrial. One of the cases cited by the state.
Before you move there,
Okay.
Can you clarify for me if you are saying that we do a layered approach of looking at the statutes and the Constitution, or are you saying if you don't meet the statutory
I don't know.
provisions, you're finished?
I think that's an interesting question. I don't know that this court has ever addressed the issue, because we have a statute that says when double jeopardy is implicated, that is narrower than what the Constitution provides. And so is there an issue, ultimately, is the double jeopardy statute somewhat like the speedy trial statute in that there's an additional layer of protection? In our brief, we discussed the statutory provisions. I think it laid out maybe 3 statutes that or 3 subsections that were of interest to me. In this brief, it says 21-5110, a prosecution is barred if the defendant was formally prosecuted for the same crime based upon the same facts if such former prosecution was terminated without the consent of the defendant after the defendant had been placed in jeopardy, except where such termination shall have occurred by reason of illness or death of an indispensable party, the inability of the jury to agree, or C, the impossibility of the jury arriving at a verdict. We don't have any of those provisions impacting on this declaration. So if that statute provides broader protection than what the constitutional provision does, then obviously there doesn't appear to be any justification under that statute for declaration or for requiring the defendant to face a second trial in this case.
So based on that argument, you would not even apply the mistrial statutes?
Pardon me?
You would not even apply the mistrial statutes? You would, the
That
mistrial
statute
statutes are broader than the double jeopardy statute, so how did we harmonize that?
Yeah, well, I think that statute would prohibit a retrial of this case, because and that's what the court, I think, addressed that statute in Cady, but in the Cady decision they applied, I think, a more traditional judicial opinion approach to retrying. I don't think they would strictly apply that statute in Cady, but is that statute somewhat akin to the speedy trial statute in providing broader protection than what the Constitution does?
Could I clarify? You're saying the mistrial statute deals with the declaration of a mistrial in the current proceeding.
Yes.
And double jeopardy then would define when you could have a retrial.
When you could
have a mistrial that would not result in a retrial if it violated the double jeopardy statute, even though the mistrial may have been appropriate under the mistrial. Is that your argument?
Yeah,
Okay.
I think that's one way that this could be looked at, is that the double jeopardy statute provides a broader protection, just as the speedy trial statute provides a broader protection. Perhaps.
Sorry, I didn't mean to interrupt.
Okay, that's okay.
Is AJMB an indispensable party? Under the
She's not a party.
who is a party in the
Richter Bowman in the state of Kansas.
So the only way under the double jeopardy that you could have that provision about illness or death would be if Bowman dies?
I would think so. I would think that the legislature would know the difference between a party and a witness. I don't believe that those would be the same thing necessarily, because as this court has observed on the difference between the convictions and adjudications, legislature knows the difference between those terms. And I would think they would know the difference between a party and a witness.
Let's take that a step further. Is this child an indispensable witness? Aren't there means by which this prosecution could have gone forward if she had been declared incompetent at that hearing prior to trial? There are some mechanisms by which the state could have proceeded.
I believe without a doubt she is an indispensable witness. And that's what brings us into the Supreme Court line of cases, 10th Circuit line of cases about failure of critical prosecution evidence and the lack of Supreme Court precedence in allowing a retrial when there's been a failure of critical prosecution evidence.
That was my, I guess, kind of lead into my question previous, is what statements had the child victim given? Because there's a mechanism that allows that statement to come in. There's a hearsay exception, 6460 double D, isn't there?
No, not after Davis versus Washington and Crawford versus Washington. Those statements violate confrontation clause. Statements made to police officers under Davis versus Washington are inadmissible and
so 60. Do we have a case that says 6460 double D is no longer an exception to hearsay?
well, all I can do is cite you to Davis versus Washington.
I don't believe we've addressed that issue. Correct me if I'm wrong. Have we said that hearsay exception violates Crawford and the cases?
I've cited some cases in my brief where this court has reversed convictions due to inadmissible hearsay and child molestation type cases. And I believe State versus Noah, where there was hearsay admitted over defendant's confrontation rights. That was decided following Crawford and Davis. State versus Henderson, another 2007 case, decided after Davis and Crawford, where convictions were reversed. In Henderson, FJI was unavailable to testify due to her inability to understand questions posed to her in the courtroom, as well as the oath and the requirements to tell the truth. This court affirmed the Court of Appeals reversal of Henderson's conviction since FJI's recorded statements were testimonial and violated Henderson's confrontation right. So I think this court has addressed those issues.
Counsel, if you're done answering Justice Rosen's question, you're out of time.
Okay.
Would you like 30 seconds to wrap up, or do you want to wait till rebuttal?
Yeah, I had a list of about 6 factors here, but one of the things that was mentioned is failure to explore alternatives. In the Dunn's case that's cited by the respondent, in that case, rather than declare a mistrial, the court adjourned the proceedings for 3 months before eventually declaring a mistrial. So adjournment was an option that did not get considered by the court. The state says, described this as a no-win situation. They were not able to proceed. That's what the double jeopardy protects against. We didn't run from the trial. We stayed in the trial. And we'd asked this court to issue a writ of habeas corpus ordering dismissal of the underlying prosecution. Thank you.
Thank you, counsel.
May it please the court, Mr. Chief Justice, Christine Ladner, Assistant Saline County Attorney for the respondent. The state asked you to deny the petition for writ of habeas corpus. If I may, I want to begin by addressing some of the questions that were posed. Justice Johnson, the inquiry is AGMB an indispensable witness in this case? She is a key witness, but as Judge Johnson was wrestling with what to do, he was already beginning the analysis of, could the state proceed with hearsay of AJMB under 6460 double D? And then Justice Rosen was asking, what statements were there before the forensic interview came in? Were you going to say something?
Could you have tried this without her?
I could have, if certain motion practice had been in place.
Excuse me, you could have with procedures, I got that. And you would have called her first.
If I was going to try the case without her, I would not have called her at all.
Right, but another method is to call the person first to determine whether you have a 460A situation where you have a witness available for cross-examination, right?
Yes.
And so what I'm getting at is a lot of this problem was because of the state's choice of how it wanted to try the case.
Justice, I'll tell you that I began in absolute good faith thinking that AJMB just 13 days prior was great after she warmed up. She was bubbly, she was a bright, shiny penny. It was devastating when she would not even take the oath. My method was to present just the case in a little bit of the chronological order and how the disclosure came to light, and call her before that key piece of evidence, the forensic interview. In terms of what statements were there before that forensic interview, number one, her disclosure in the middle of the electronics aisle to Mom at Walmart. The next way that would have come into evidence is Mom's second phone call was to Grandma. Oh my God, AJMB just told me this, what do I do next? Number two, Mom called her lawyer before she called the police. Then Mom calls dispatch, the 911 call. Then the officer shows up to take the report from Mom, and Mom gives a written statement. Up until that point, there's no law enforcement direct inquiry to AJMB. It's not until she shows up for the forensic interview, and that interview would have absolutely been considered testimonial under Crawford, State versus Henderson, and all of that. Judge Johnson, the trial court, also noticed that after this disclosure came out, AJMB went into therapy. So I think that there are statements for a therapeutic reason that were made by AJMB about the disclosure of the abuse and so forth and so on. And there would need to be motion practice on whether or not the statements to the therapist would be considered testimonial or not. Justice Lukert inquired, is that all it takes, an objection? You know, what about a layered statutory analysis about the mistrial statute? In answering that question, just a word about preservation. This is an original action, so in terms of constitutional implications, statutory interpretation, absolutely de novo. But I would point out that there are so many places in the record where great deference, I think, should be given to the trial court's interpretation and personal observations of what was happening in this district court. Number one, the preliminary hearing, where he had the opportunity to see the forensic interview and how this child disclosed the abuse, what her level of ability was to communicate about the facts in question.
Excuse me, counsel, that all goes to the constitutional standard, doesn't it?
These factual supports for Judge Johnson's findings?
Yes, I mean, that goes to whether you can meet whatever burden you have, whether it's strictest or some other interim burden, right?
Strictest scrutiny,
Yeah.
manifest necessity.
Yeah, I mean, I'll tell you what's troubling me is the double jeopardy statute and how much broader it purports to be. I think if we look at that in the way we normally look at statutes, it's
Are you
pretty
looking
clear.
at 215110?
Yes.
I'm sorry.
Yeah, that's what I'm looking at. That's what's troubling me. To me, it seems pretty clear, not ambiguous, and it just seems to provide more protection to a criminal defendant than either the mistrial statute or the federal constitutional standard, which is apparently, according to previous decisions, coextensive with this Kansas constitutional provision.
I'm looking at the times that the word impossible appears in the mistrial statute and how it also appears in the double jeopardy statute. The impossibility of the jury to arrive at a verdict. You could say, well, that only goes to hung juries. And Judge Johnson's analysis of finding that mistrial was appropriate under both subsection A, it's impossible to proceed, and on subsection C, prejudicial conduct inside the courtroom. And by the way, that's not about the admissibility of hearsay. I think Judge Johnson's finding of prejudicial conduct inside the courtroom is failing to press the gray button to mute the sound that was going on in the adjoining courtroom where AJMB was, makes it impossible to proceed. So to the extent that they conflict, I get it. But then going to the constitutional analysis, double jeopardy is not triggered. If there's a mistrial, what's the standard for that? Was there manifest necessity, even under a strictest scrutiny standard? Going back to review the trial court's ruling on when he granted the mistrial and denied the motion to dismiss, it's so rich with factual references back to the record.
Can I back you up just a second for clarity? Justice Breyer was asking you about the double jeopardy statute 21-5110, and I understood you to say that you are proceeding, the theory of your case proceeds under subsection A3C, the impossibility of the jury arriving at a verdict. Is that right?
I really only briefed this under the mistrial statute. And the constitutional provisions, I was relying on the body of case law. When there were questions about this double jeopardy statute, I really noticed this impossibility language.
So you're saying two different possibilities under that statute, because whether you briefed it or not, we need to deal with it. So just to be sure that we understand I thought I did understand your response, but I want to make sure that you think that the statute could be complied with here in at least two ways. The first way being that it was impossible to proceed to a jury verdict. And you say it's impossible because there were all these problems. And the second one being that there had been prejudicial conduct inside the courtroom.
Yes.
That either of those would apply. So
Yes.
It's not just the one that your opponent was relying on.
Correct.
How does that prejudicial conduct factor fit with 5110? I just don't see it on the face of the statute.
I'm referring to the mistrial statute.
Okay, well maybe that's just the source of my confusion, but
I share your confusion.
looking at 5110, which is the double jeopardy statute, it says that you can't retry the defendant when you terminate the first proceeding without his consent, unless and then you have three exceptions, and there's only three, A, B, and C. A is illness or death of an indispensable party. Do you allege that exception applies here?
No.
B is the inability of the jury to agree. That's a hung jury.
Correct.
You don't allege that exception
No.
applies. And the only remaining exception is C, the impossibility of the jury arriving at a verdict.
And then I'm referring that impossible language back up to the mistrial statute, prejudicial conduct inside the courtroom, making it impossible.
So you're
to
saying
proceed.
that the court's declaration of a mistrial in the first trial implied or implicit in that was the judge's finding that it would have been impossible for the jury to arrive at a verdict.
Yes, sir.
Okay.
Why would it have been impossible for the jury to arrive at a not guilty verdict?
It wouldn't have been, would it?
Well, we don't know that, but what Judge...
But that is a verdict. And they could have done it without your witness, right?
Impossible for the jury to arrive at a verdict. What the trial court was wrestling with was, suppose we allowed this case to proceed. Based upon what the evidence is, it would be inherently error based upon the inadmissible hearsay that had already been admitted. It would have been an exercise in futility.
Not if the jury acquitted the defendant.
It's impossible for the state to win, but that isn't what the statute says. It says arrive at a verdict.
I still don't think that the constitutional provisions bar retrial in this case
But we're
The
concentrating on the
statute.
statute.
on strict statutory language.
Could you, just to kind of clear up the scenario here, there was a discussion that took place and the mute button or some button wasn't pushed that allowed the child victim to maybe, was there a record made that the victim actually overheard or understood what this discussion entailed?
There's two places in the record where the trial court talked about that. The record from March 20th of 2018, around page 96 forward. What happened was he realized that he had forgotten to press the mute
This is
button.
the judge.
The judge.
And so there was a discussion that took place at the bench.
At the bench between counsel with the court reporter
Okay.
there. And the judge says, I didn't realize it, but I neglected to press the mute button.
And the discussion had to do with the witness's availability.
Yes.
Or inability to take the oath, all that.
So that was, go ahead.
No, and so there was this, do you know if the victim even heard this? Or, I mean, it was on. That doesn't necessarily mean that even understood what was going on. I'm just trying to get a picture of how that could be so damaging to the case that it would have to be.
I knew, judge knew, I think counsel knew that could be heard in the adjoining courtroom. When we took a recess and came back into the record, it was apparent, the record says she was even more so not going to engage. The conversation at the bench was all about her. She's refusing to testify. She's being coerced. Obviously she was right there. It was before she ran away.
Could I get you back to some statutory interpretation? You want to rely on the mistrial statute 2234-23, and you talk about impossibility, but subsection 1 says physically impossible to proceed. And I don't understand, just because the state's lost their critical witness and they probably can't win without that witness, why does that make it physically impossible to proceed?
Justice Johnson, I want to tell you, I did not address this issue because from my reading of the case law, double jeopardy is not triggered if a mistrial is granted. So to me,
the mistrial statute says one reason you can declare is if it's physically impossible to proceed. You've said a number of times it was impossible to proceed, and that's why it's okay, but you're conveniently leaving off physically. Impossible to proceed for the state to win is different than physically impossible to proceed. And I'm trying to understand why the loss of a witness makes it physically impossible to proceed with the rest of the trial.
I think the trial court's interpretation of that, it would have been futile.
Futile because any guilty verdict would be inherently tainted.
Fatal.
But don't you run square into the defendant's objection to the granting of the mistrial at that point?
Meaning,
I understand how you're characterizing the district judge's dilemma. If the district judge truly thinks, well, there's just prejudice to this defendant that is not curable. That's the normal mistrial scenario. But here you have the defendant saying, I don't want a mistrial.
and so where the defendant does not consent to the mistrial and the other factors in the mistrial statute apply, are those factors supported by evidence, abuse of discretion, and then is there manifest necessity under strictest scrutiny? And so the classic example is a hung jury. There's no prosecutorial misconduct that caused the mistrial. What about where the witness is unavailable and that's the reason for the mistrial? Then there's discretion there, and what's the reason? This was unforeseen. Did the court try to consider other alternatives in saving the case? Could we dismiss some counts? I gave a recess. Even after the recess, it was apparent that the witness was not going to come forward. I think the trial court did consider alternatives before granting the mistrial, and at the end of the day, like taking a 3-month recess, for example, would not be appropriate.
Counsel, I'd like to go back to the double jeopardy statute. And you were answering some of my colleagues' questions about the subparagraphs that would allow another prosecution to proceed on A, the illness or death of an indispensable party. I believe you've agreed that yes, she was not an indispensable party.
Yes.
And the second, there is no hung jury.
No,
Correct.
there was no hung jury.
So that would leave you with, it's impossible for the jury to arrive at a verdict.
Yes.
And I don't recall what your answer to that was.
I-
Are you using your response to the mistrial statute about physical impossibility, i.e. it would be, according to you and the judge, it would have been futile to proceed? Is that your answer for the double jeopardy statute? Or am I mixing issues?
My answer to the question about the double jeopardy statute, because the language uses the word impossibility, it makes me, as a matter of course, go back up to the mistrial statute. The word impossible. I think it would have been impossible to arrive at a verdict. Do we know that? We don't. The judge elected not to do that. But whether this factor, this statute, the impossibility of the jury arriving at a verdict, whether it applies within the statute or constitutionally overarching, double jeopardy is not triggered if the mistrial is appropriate. I go back to that principle of law and then apply what Judge Johnson decided in terms of, was the mistrial of manifest necessity, even under a strictest scrutiny standard? I ask that you agree with him.
So your belief in trying to harmonize at least these two statutes is that the mistrial statute would trump the language of the double jeopardy statute?
Yes. I feel like I have not answered the questions that were raised by the court. If this case were sent back and allowed to proceed again, Judge Johnson, the trial court, was already contemplating what motion practice or what procedures could go into place to make sure that this does not happen again. And what he talked about was the closed circuit TV statute allows for either a live presentation of evidence or testimony that's recorded, similar to a videotape deposition. If that procedure were followed, that competency determination would be done ahead of time outside the presence of the jury, but still with all the procedural due process in place of the statute. And then at that time, if it is clear that the child was not competent, then the motion practice of what non-testimonial statements under 6460 double D could come in could then be done at that time. I ask that the writ be denied. If there are no further questions, I'm out of time.
How does that comport with the concept of double jeopardy? What I hear you saying is that if we send it back, the state and the court is going to try harder to be able to get this prosecution to go through successfully. And the concept of double jeopardy is that the state gets one chance. They don't get do-overs, isn't it? Isn't that the concept?
It is. Mistrials happen all the time.
Well, I understand, but what you're saying is that you want to go back and change the procedures and change the way that you present the evidence. You want to change the manner of prosecution, which is different than a prejudicial conduct requiring overs. You want do-overs, is what you want.
I do, Your Honor.
Yeah.
Mistrials happen all the time. Whether a juror breaks their leg and the parties don't agree to continue with 11 jurors, a witness has a medical episode, does the state, for a mistrial like that, does the state get to go again and try again another day? The state does, because there should be a balancing of the defendant's interest in going to trial only once and the state's interest in seeing the case closed with justice. If there are no further questions.
I see none. Thank you, counsel.
And what Ms. Ladner poses is a good example of the impossibility of for the case to proceed to verdict is the case where something happens to a juror and the parties are unwilling to agree to less than the required number under statute. That would be
What would have happened here if the judge said, nope, we're going to proceed?
We would proceed.
And you would have proceeded and the hearsay evidence would have come in? Or what would have happened?
If she testified according to what she related in the CAC interview, then
No. I'm saying that the witness couldn't offer any testimony.
Okay.
But the judge, nope, we're going to proceed anyway.
Yeah.
We're going to allow in all this hearsay.
yeah.
What you wouldn't have moved for a mistrial at some point?
No. That was very weak evidence at that point. Now, I did tell the court that if he allowed in the CAC interview over objection, I would be moving for a mistrial. If he allowed that in, I'd be moving for a mistrial because that would greatly offend the confrontation rights of Mr. Bowman. These other things were just passing references of, well, she said he had touched her, or if you look at the transcript, they're not even sufficient to prove the rape or the sodomy charges, if you look at the transcript. So if it was stuck at that, I think this court or the trial court would have been obligated to render a judgment of acquittal based upon what had been admitted up to that point. The physically impossible to proceed, that portion of our statute, I believe that comes right out of the Wade versus Hunter case from World War II, where they had to move the court location, or the court was unavailable due to changing battlefield conditions. And that case is cited as the only case where the United States Supreme Court has allowed a retrial due to witness unavailability or failure of critical prosecution evidence. Arizona versus Washington says that failure of critical prosecution evidence also elevates this to strictest scrutiny.
If this case does turn on that language in 5110 subsection C, impossibility of the jury arriving at the verdict.
Yes.
What scenarios satisfy that? You touched on this a little bit.
As I indicated, she offers an example. If a juror breaks a leg or has to go into the hospital or something, and neither side is willing to stipulate to less than 12 members, then the jury obviously would be.
And this gets to my question. Doesn't subsection C hinge on fact-finding? And we don't have any fact-finding here. Do we need fact-finding?
Well, I don't think there's nothing to base fact-finding on.
Well, whether or not it was impossible for the jury to arrive at a verdict.
Yeah, there are no facts that suggest that in this case, and that shows that
there aren't any facts at all.
Well, yeah, and that shows that the mistrial doesn't survive strictest scrutiny.
Well, no, I'm asking. I get you have your other argument about strictest scrutiny, but if we're just looking at this statute as point one, because if you win on the statute, you win. We don't even have to get to the constitutional question. I'm just asking the question: how do we know?
Well,
how do we, as an appellate court in a original action, know whether or not it would have been impossible for the jury to arrive at?
I think your obligation is to apply the strictest scrutiny standard. And does what's been produced to this point hold water? If the answer is no, then the double jeopardy right is offended by.
That's the constitutional analysis.
Yes. Well, it's also, I think it would also be statutory analysis.
Well, whose burden would it be under 2151.10 to show that subsection C, 3C applies?
Well, that would be
the state.
That'd be the state's burden in response to our motion to dismiss that we had to establish factually grounds, and nothing was done at that point. There was no evidence presented, and so there is no facts to base a manifest necessity that survives strictest scrutiny on in the analysis.
It's hard to intuit how that subsection could apply to a criminal proceeding when a failure of evidence is, you always have the not guilty. verdict. I can see where that would, where a jury had to decide, does A win over B on a contract dispute or whatever, and the trial was such that it's impossible for anyone to reach a verdict. But on a criminal case, there's always not guilty.
Yeah, and the Constitution doesn't guarantee the state a win. That they're unable to proceed or call this a no-win situation, that doesn't show a constitutional sort of issue there. That's just a frustration with the case. The Constitution doesn't grant the government a right to win.
Do we have any further questions? Thank you,
Okay,
counsel.
thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement. This